Hello. So I want to think about more about manslaughter, gross negligence manslaughter. So this is when there's a breach of duty. So in order for this to be found, there must be gross carelessness which leads to the death of a person, and there's got to be a legal duty to care for someone. These duty this could be an act or could be an omission. So these exist in particular relationships. For example, a swimming pool lifeguard has his duty is to save those who are in the swimming pool, or doctors and nurses they have this duty to their patients and so on. Okay, so sometimes there's a duty of affirmative action as to actually do something. And the death might be is a matter of law, and the trial judge will decide that. The curious thing is, in the civil law area of negligence, duties arise when the duty holder is in a position and their actions are going to cause harm if the person isn't careful. So criminal law follows this pattern to some degree. But there's a duty is not recognised in civil law doesn't mean that it's not recognised in criminal law. Sometimes there's no duty in civil law, but the same situation there is a duty under criminal law. Confusing, I know. Okay, so Wacker 2002 was a case about this. In this case, a lorry driver, he accepted a large payment to allow dozens of illegal immigrants to stow away in the back of his truck, and he drove from France onto a ferry into the United Kingdom. But there's a problem with the ventilation, and they all died from asphyxiation. So anyway, he was found guilty of manslaughter because of his failings in this regard. But under civil law, he had no duty to them, because he had no duty to look after these illegal immigrants in the back of his truck, even though they were there with his express consent, because he's getting paid to take them in. And they, of course, they were complicit in this enterprise. However, this stricture was disapplied from criminal law, where there were other considerations. So that he did have a duty to try and save their lives, and not to do something dangerous, which resulted in their dying of suffocation. So there was Willoughby in 2004. In this case, two men, they burnt down the defendant's building, Mr. Willoughby's building, as part of an insurance fraud scam. But they set fire to the building, but that led to the victim dying, as in the defendant's friend, accomplice, who was his co-adventurer in burning down this building, died as a result. So so there would be no duty of care under civil law. The victim, he was an accomplice in this crime. But there was a duty in criminal law. You started a fire as an unnecessary fire, a fire with a view to causing a crime, and that led to somebody else's death, so therefore you're guilty of manslaughter. So gross negligent manslaughter, it moved on a lot from a case called Adamarco in 1995. There was an anaesthetist, and he was charged with manslaughter because he didn't surveil and superintend his patient prudently enough. The patient was under general anaesthetic during an eye operation. The patient died because the anaesthetist was inattentive and didn't notice the chap's oxygen supply had been stopped. So the House of Lords made a number of vital observations during this case. They said that the trial judge had used the word recklessness here in relation to the fourth element, so they deprecated that. And the trial judges should direct juries in gross negligence only in cases where the lack of care is said to be the cause of death. So in this type of manslaughter, there are three elements that the prosecution needs to demonstrate the existence of. Number one, the defendant owed a duty of care. Number two, the defendant was in gross violation of that duty of care. And number three, the death occurred consequent on this breach of duty. So let's go into those elements one by one. The duty of care. So as I already adumbrated, this is a matter of law, and the judge will decide whether the defendant owed a duty of care to the victim or not. And if that duty was broken, and was the death caused by the breach? So Evans 2009 was a case where this was affirmed. The Court of Appeal said there's a new duty situation. That's when there's a manslaughter by omission. So where one arising of the victim contributes to circumstances of high danger for the victim. So this builds on the principle laid down in Miller, the House of Lords had limited this duty to cases where there's a dangerous situation which was occasioned by the defendant's action. And it's sufficient that he simply contributed the danger. It doesn't have to be the sole creator of the danger. This is what the Chief Justice Lord Judge said. When a person has created or contributed to the creation of a state of affairs which he knows or ought reasonably to know has become life-threatening, a consequent duty upon him to act by taking reasonable steps to save this other's life will normally arise. Close quotation. So if the defendant has created or been partly responsible for creating, there could be other people or other factors that created the dangerous situation, that the defendant knows or should know this could be life-threatening, he has to save the person from the danger he's created. Well, let's look at the breach of duty. So just how badly does someone have to perform his duties in order for this to operate in the case of gross negligence manslaughter? Well, egregiously badly. It can't be slightly badly, it can't be fairly badly, it's got to be really bad. So in Adamarco, this is what Lord Mackay of Clash Ferns said. Responsibility will depend on the seriousness of the breach of duty committed by the defendant in all the circumstances in which the defendant was placed when it occurred. The jury must consider whether, having regard to the risk of death involved, the conduct of the defendant was so bad in all the circumstances as to amount in their judgment to a criminal act or omission. Close quotation. Okay, so it's got to be extraordinarily bad. It can't be just minor mistakes that everybody makes. So there's liability for gross negligence manslaughter. There has to be some risk of death, not just a risk of slight injury. Okay, it can't be so if you accept there was a risk of slight injury, but actually the injury turns out to be fatal, then that's not going to operate, because that would be too strict. That would catch too many people, would be overly cautious. So the risk of death has to be clear at the time when there's a breach of duty. For example, somebody's under general anaesthetic, you know they require an oxygen supply. If you don't keep an eye on it, they could easily die. That was Adamarco. Okay, there's a case called R and Rose about this, 2017. I remember saying that the risk of death has to be obvious at the time the breach occurs. So, an optometrist was not carrying out the eye examination properly, and because of his lack of prudence, he didn't spot something in the eye. If he'd known that, he would have realised that this woman had a life-threatening condition. He would have pleaded with her to get urgent medical attention. Anyway, he was later found guilty of gross negligence manslaughter, but that was overturned in appeal because they said that the optometrist's failure to carry out proper examination was very negligent. But I mean, the eye examination should have revealed a life-threatening disease. That doesn't mean that there was a serious and obvious risk of death, as they said. Okay, if the examination wasn't carried out. It was an ordinary eye test. That was not really her duty, was to be looking for life-threatening things. Now, it would have been different if the patient had come along saying, well, I've got these severe problems, which would have led an ordinary optometrist to realise that something might be up like that. Okay, so there's R against Kudus 2019. In this case, there was a guy who owned a fast food place. And a diner came along who had a peanut allergy. Now, the diner had told the previous owner they had a peanut allergy, but he hadn't told the new owner. So the new owner served him something with a trace of peanuts, and that led to the person's death. So there was no default on his part in terms of health and safety regulations. He was following those with regard to allergies. And this risk of death wasn't obvious to anyone because he didn't know the customer had the allergy. So anyway, some people said that gross negligence manslaughter, it breaches Article 7 of the European Convention on Human Rights, which says you can't retrospectively criminalise things. There's a difference between mere negligence and gross negligence. Mere negligence is ordinary negligence, ordinary mistakes or omissions that people make in the course of their duties. Okay, nobody's perfect. Gross negligence has to be exceptionally bad. So if a person's behaviour is gross negligence or not, it's difficult to say. And you can't tell that in advance. Only a jury can decide that after the act has occurred. But saying, oh, well, you can't do me on this because it's a breach of my convention rights, that argument was thrown out in Amit Misra 2004. Okay, that's enough for the moment. Toodaloo.